Court is currently dealing with a very interesting petition. The petition wants Hindus to be granted minority status in states and union territories where their numbers have gone below other communities. Now, in response to this petition, the centre has said that states can in fact designate Hindus as minorities if they are lesser in number in that particular state. Of course, the entire issue is a lot more complicated than this. So in today's KYC episode, I'll tell you what a minority is, what the definition is, and who decides who is a minority. Now, the court has been approached by a lawyer, Advocate Ashwini Upadhyay. He's filed a PIL demanding that minorities should be determined at the state level and not the national level. Let me first tell you how it's done currently in India. Right now in India, minority communities have been notified under Section 2 of the National Minorities Commission Act 1992. The central government has done this. It has decided who will be regarded as a minority. Basically, in October 1993, the central government notified 5 groups: Muslims, Christians, Sikhs, Buddhists and Parsis as minority communities. Jains were added to this list in January 2014. Now what Upadhyay has asked for is, he's argued that this system was faulty because Hindus were actually a minority in 6 states and 2 union territories. So the PIL says that as per the 2011 census, Hindus have become a minority in Lakshadweep, Mizoram, Nagaland, Meghalaya, Jammu and Kashmir, Arunachal Pradesh, Manipur and Punjab. You can see the figures on your screens right now. So he has objected to Muslims getting benefit of minority schemes in Jammu and Kashmir where Muslims are a majority and Hindus are a minority, or Sikhs getting benefits of such schemes in Punjab where Sikhs are in fact in majority while Hindus are not. So he has also objected to majority Christians in the states of Mizoram, Nagaland, Manipur, Meghalaya, Arunachal Pradesh, Ladakh and Lakshadweep getting the benefits of minority schemes in these states where they are in fact the majority, because these benefits of course have been given on the basis of the central list that I just told you about. So Upadhyay basically wants this power to be given to the states and not the centre. He said that the centre has given itself unbridled power to declare a community as a minority, but the centre has now said that this is in fact not correct. Now here, for a brief moment, let us first understand what minority means. The word minority appears at 4 places in the Constitution, in the head notes of Articles 29 and 30 and in clauses 1 and 2 of Article 30. But the Constitution does not define minority. Article 30 talks about minorities. It mentions 2 types of minorities: linguistic and religious. So, for example, constitutional expert Faizan Mustafa has often in fact said that in a few states, Hindus are in fact religious minorities, and in the entire country they are linguistic minorities based on the language that is used in different states. And what do minority communities get? Under the Constitution, they are entitled to several benefits. For example, under Article 30, minorities have a right to run their educational institutions. And how do we decide who is a minority? Now, logically speaking, the first thought that of course would come to your head while thinking about minorities would be on the basis of numbers. A minority is a group that is numerically smaller than the majority in a given society. Apart from this, the Supreme Court has also held that any community, whether religious or linguistic, which is numerically lesser than 50% of the population of a state, is entitled to the protection of minority rights. And the Supreme Court has already in fact said that minorities are to be defined at the level of the states, meaning that for Article 30, minorities have to be considered state-wise. Why did it feel so? Because it said that since states in India have been reorganized on linguistic lines, therefore it makes sense that linguistic minorities should also be determined state-wise and not for the whole country altogether. So now, in response to this petition, the central government has basically clarified this position. It has filed an affidavit saying that states can in fact grant Hindus minority status if the community is not a majority in those states, and it has said that both the central government and the state governments have the power to declare such communities as religious or linguistic minorities within their respective territories. So it has basically, what it has done is clarified this position on the basis of Supreme Court judgments and the Constitution. The affidavit has said that Ashwini Upadhyay's allegations in the PIL are actually not correct. The centre has explained that Parliament and state legislators have concurrent powers to enact law to provide for the protection of minorities and their interests within their territories. So basically, to once again break it down even further, even if Hindus have not been declared as a minority nationally, the centre has told the court that respective state governments can still feel free to do so at their respective state levels if they notice that the numbers have gone down. As an example, the centre has also told the court how the government of Maharashtra has in fact notified Jews as a minority community within the state. The Karnataka government has notified Urdu, Telugu, Tamil, Malayalam, Marathi, Tulu, Hindi, Konkani and Gujarati languages as minority languages within their state as well. So basically, quoting these examples, the centre has said that state governments are already free to declare minority communities within the state, and hence Ashwini Upadhyay's petition should be dismissed. So now finally we'll just have to wait to see what the Supreme Court says on this. This is Apoorva Mandhani for ThePrint. For more such videos, do subscribe to our YouTube channel and follow us on Twitter, Instagram and Facebook.